Okay, so I want to get started. Welcome everybody. We've only got a handful of folks here live and in person, but we've got about 25 or 30 online. So as always, if there's a problem with the audio or the video, let us know by way of the comment section so that my staff can try and get that remedy. It's about 5 after, so I thought we'd get started. The good judge, Tanya Garrison, is here to give us a talk about spoliation issues. She and I almost every year have a bet over the Texas-Oklahoma State game. Almost always I win, you know, but life is fickle. Some days you win, some days you lose, some days you lose by 48-0. You never know.
Sometimes it happens.
Sometimes that happens. Sometimes. So I'm wearing this beautiful Barry Sanders jersey.
It looks really good on you.
Well, thank you. I think it's very slimming. So if anybody's wondering why I look so good today, it's because of the judge.
And I would say you were not the last person who wore that was not me.
It was Barry.
Was Judge Miller, who lost a similar bet and had to go block walking in an OSU jersey.
Well, for the kids at home, don't gamble. Sometimes things don't work out. So we were going to have Russ Hollenbeck here. He's not available to join us, unfortunately, but we do have Judge Garrison. We've also got Jared Elzey, who actually worked on this case that he'll be talking about today, who might chime in with a few thoughts. With that, I don't think I have anything else. We want to thank our sponsors real quick, Oasis Financial and Pipkins Investigations and Breeze MRI. If you need an investigation or some client funding or some MRI services, please track them down. They will be in the email that comes out after this presentation. Finally, there is a really good paper that goes with this topic. If it hasn't been sent to you already, it will be sent to you later on this afternoon so that you can refer to that if you have any other questions about this topic. With that, my pleasure to introduce Judge Tanya Garrison. Come on up.
Kyle.
Okay,
great. And I have got to give about 57 disclaimers before I do that. Russ is really the brains sort of behind this project. I was just telling Kyle, he is like the play-by-play guy and I'm the color commentator that just gets to provide sort of like the 36,000 foot view on all of this stuff. There's a PowerPoint, but it's Russ's. He did such a good job and I just play along. So because he's not here, I'm just going to try my best to cover this. And because this is a more intimate group, if anybody has any questions, just stop me. Or online, if you guys see something come up, like stop me and just tell me what they are and let's just talk about it, because a lot of stuff in the law, as you guys know, it's like you brainstorm with your colleagues and your friends about how to get to the right answer because there are no crystal clear answers. So let me tell you a little about how we came to this. I am at work minding my own business, and this case falls into my court, and Jared is the plaintiff's attorney representing a family with a little girl in short, she's sitting in a shopping cart at a Michael's craft store. The cart falls over. There's a dispute over what caused the cart to fall over and how it fell over. And if you've ever been at a Michael's, it's right there when you're fixing to go pay, right by the cash register. And like all stores, all box stores, of course, they have video. It's a pretty big fall, but you know, like most things that happen, you're hoping it's not that big a deal. You pick up the child's screaming and crying, mom is screaming and crying, but you hope it's going to be okay. Mom takes kid out of the store and they go on their business for the day. Several days later, kid is still pretty injured, ends up going to the hospital, and it's really bad. It's really bad. This kid is significantly injured to the point where she'll have problems the rest of her life. It's a traumatic brain injury case. And so what is at issue here? This is a premises case. The issue is going to be, was there a defective condition on the premises? What's going to be, what knowledge, if any, did the store have about it? And what was their involvement in any of this? So things that might be of interest to the plaintiff, correct me if I'm wrong. Well, A, what happened? B, how are these carts sort of handled and treated and kept at the store? However, because this goes a few days high, Goes a few days, and then by the time parents actually consult with an attorney, it's not like the next day. They don't jump to that, but they do get an attorney involved pretty quickly, and this attorney sends a evidence. They're trying to call Michaels. Their story, take it for what it is worth, but I presume it's true at this point in the litigation, is I'm trying to call Michaels. But I'm getting the runaround, I'm getting customer service, nobody's doing anything. The attorney sends a preservation letter, but it's on day 33 after the accident, okay? So not day 29, which would have been different, but day 33. Michaels says in the litigation, we get rid of all of our video after 30 days. So sorry, we don't have any of it. However, they never, when they get the evidence preservation letter, they never go look for it to see if they still have it, if it's cloud-based. I never get any really of this. There's nothing there. They don't go look for it for 6 months, 8 months, some really long time after a insurance adjuster actually kind of gets involved. So fast forward to the hearing and they say, we don't have it. And so the plaintiffs say, spoliation. And we have to go through sort of this analysis, and it was very interesting. I found it very intellectually interesting how this case law has developed and where it sort of stands. And the reason I found it intellectually interesting is that if you're like me, look for sort of the shortcut answers in the practice of law, right? So you can do this, yes, you can do this, no. Like, what are the rules? And you start listening to a narrative, and the narrative is there's no such thing as spoliation in Texas. You can't get a spoliation instruction. And you sort of get conditioned to believing that it's like a unicorn, the rare exception where you could ever get this. And the truth is that that's not true. The truth is that the way I looked at it was Brookshire Brothers, the main case we're going to talk about today, laid out a recipe. If you want a spoliation instruction, it's not going to be easy, but here's the recipe you need to go through to get there. So it lays it out. I just have to follow the recipe. And if the plaintiff gets to this, then I need to give it some serious thought about whether or not this was sufficient enough conduct, sanctionable enough conduct to rise to the level of some sort of sanction. And I do. I did rule in favor of the plaintiff. I don't think I gave them, they were cautious. They didn't ask for, the death penalty sanction, the jury instruction. They asked for something lower, and I gave them something lower. I crafted a lot of it myself, but their input was definitely important in it. Okay, so I issue an order. Plaintiff gets some stuff. Defendant freaking out. But literally, Russ, in the middle of the hearing, it was a pretrial conference. We are going on about some other stuff. Russ asked to leave so that he can go file his mandates. So they do that. The case gets stayed. We now are waiting for, 6 months, 8 months, something like that, for the ruling on the mandamus. Mandamus is, I thought we were, and I'm not the party, I'm just the person who wrote the order. I thought it was dead on arrival. I thought there's no way. They're going to look at this and say some hippie trippy liberal pinko commie judge did this. She never should have, but the mandamus gets denied. They come back to me. I'm now setting them for trial, and they go to the Texas Supreme Court. I'm waiting for the Supreme Court to stay us in minutes so that they can make a decision on what they're going to do. The party selling. So it's now very final. Which is why I'm free to talk about it. And of course, I talked with all the lawyers and said, hey, this was really interesting to me. And I think that this is something that we could do a CLE on. And part of that reason is, and I mean this no disrespect to the plaintiff, because they did a great job presenting this case to me, giving me the tools I needed to do what I thought was the right thing. But Russ Hollenbeck, my co-presenter, wrote what I thought was a great brief to the Texas Supreme Court. And I read it. I said, oh, that was fun. That was cute. I knew all the reasons it was wrong, but I thought Russ would be a great guy to do this. and really educate people about the truth about spoliation. The other reason I wanted to do this is because I think that, there's 24 of us civil district judges at the courthouse. This issue, it does spill over into family. It does spill over actually into criminal law, because, they share these evidentiary standards. Is at any given point, 3 or 4 of my colleagues are seriously grappling with a spoliation issue. At that same point, I think all of us have one sitting around somewhere. Maybe it hasn't percolated up to the top, but we deal with this pretty regularly, considering the amount of attention that is given to the issue by practitioners. And a lot of times I think people throw it in at the last minute. They're like, oh, that's spoliation. Well, no, what it really is if you have a serious issue that you really think that this applies to, what I want to do is educate the bar about how to present this and how to set a hearing and really get the findings that you need from your trial judge so that you make sure you've gone through that recipe and that you can sustain it on a mandamus if you get a ruling that you want. This is not something you just throw together. Like, nobody would just stroll on into a injunction hearing and be like, injunction, judge. So they shouldn't be going, that's spoliation. And the judge is like, okay, we need to do more than that. So these are real significant hearings that you can put in. And if you have an issue come up and you put some serious time, money, effort into it, give the trial court what they need, it totally dispels that myth that spoliation no longer exists. So let's talk a little bit about what it is. So spoliation has existed in Texas since forever. The earliest case that we have on this is your actual CLE part, I guess, is from 1852, where the Texas Supreme Court held that what degree of diligence in the search is necessary is not easy to define, and each case depends much on its peculiar circumstances and the question of whether the loss of the instrument is sufficiently proved to admit secondary evidence of its contents to be determined by the court and not the jury. This is a case called Cheatham versus Riddle from 1852. Now, it's a bad fact case. If you can avoid citing this case, I would avoid citing this case. It has to do with a lost promissory note on the sale of a slave. So, not cool history, but it shows you that this idea of lost evidence or destroyed evidence goes back a long, long way. So after that, all of Texas jurisprudence is just kind of like, oh, there's this thing out there called spoliation, and nobody's ever really talking about any rules, any boundaries about what it means and how you deal with it. So the next important thing that happens is the Trevino versus Ortega case in 1998. So I have fast forwarded it pretty quick. In that case, it was a dentist or an orthodontist or someone, they did something bad. It was a medical malpractice case. And the plaintiff was suing them for an independent cause of action of destroying medical records. I think it was a plastic surgeon. So the guy gets injured by the doctor or whomever and recognizes it years later. So past statute of limitations, but because of the discovery rule, the case comes still good. And they say, I want my medical records. And the doctor says, I got rid of them, okay, because it's been so long. And so the plaintiff sues the doctor for destruction of evidence. And the Supreme Court says, look, this is not an independent cause of action. It is connected to your underlying cause of action. So you don't get separate damages for this. It's got to, but there's another remedy, there's another path, okay. Fast forward now to 2003. Oh, actually, let me tell you this first. There's a dissent in Trevino. Trevino takes the common judicial shortcut that says, we're just going to resolve the issue in front of us, not the rest. But Justice Baker, in his concurrence, says, no, we need to set out a test to determine what, in fact, is spoliation and when sanctions are sort of appropriate. And he lays out this sort of 3 or 4 part test that talks a lot about, let me do my next. I really blew through this. So what are the three elements you need to prove? That's really good. First, the party has a duty to preserve the evidence, and Justice Baker, the way he states it is that the party must actually anticipate or should anticipate litigation. Now that gets modified in the future, but that's what Justice Baker throws out. Then that there's actually a breach, and then that somehow this has actually hurt the plaintiff, that there is some causation and some prejudice that the plaintiff suffers. So what Justice Baker says is that the duty to preserve is that you anticipate litigation or that a reasonable person would have anticipated litigation. Now we go into the Walmart versus Johnson case. This case is in 2003, so now we're kind of getting into our collective memory of lawsuits or of the Supreme Court litigation. A allegedly paper mache reindeer falls off the shelf at Christmas time and hits a guy in a Walmart, okay? The plaintiff says, paper mache my tush, this thing was like huge and it caused significant injury. At the time of the accident, the manager of the Walmart comes and takes pictures, totally documents the file, but the guy leaves on his own. I mean, he's not bleeding and he's not, he leaves on his own power. Several days later, he's still hurt, goes to the doctor. We all heard this story in a bazillion cases. They go to Walmart and they say, because Walmart's saying it was like a paper mache reindeer. The plaintiff is saying it was like really big and heavy. Okay, let's see the reindeer. Well, Walmart says we got rid of them after Christmas. Sorry. And not only did they not have that reindeer, they don't have any. I guess they sold all of the reindeer that year. There's nothing in storage. There's no reindeer. And what the Texas Supreme, so the trial court gives an instruction, a spoliation instruction, of course it goes up. Then what the Texas Supreme Court says is that, so you can see he did such a good job. But the new case is that they must, that duty element is changed to be a little higher standard, that that there's a substantial chance that litigation will ensue. Okay, well, I mean, I don't know. The general manager totally documented it. They took pictures of everything. Like, why are you doing that unless you think litigation is going to go forward? That's just me looking at the evidence. But the Supreme Court disagrees, and they say there was nothing to put Walmart on notice that there was a substantial chance, right? So this is what kind of spawns the practice of evidence preservation letters. The need for them, because now there's a lawyer involved and everybody knows, hey, this is for real, for real. And look, here's the thing. I kind of get, you know, if Russ was here, I'll tell you what he would say. People fall down a lot at stores or in parking lots or just in life. It happens. And just because you fall is not sufficient. There has to be really some indication to the defendant because it's not fair. They're just like, no harm, no foul. You're like, yeah, I'm good, no worries. The defendant gets to kind of go, okay, hey, I'm sorry. But, you know, at what point does the defendant really have to start taking this seriously? So I get it. Do they have to save the video of every single fall in every single store and every single parking lot? No, I get it. But at the same time, I think our world, I'm going to jump all around here. I'm so sorry. Our world is changing. You know, the argument used to be, we have these 30-day preservation rules or evidence preservation issues because it's too cumbersome for us to keep 8 billion VHS tapes of everything that happens in our store. But we don't live in that world anymore, right? We live in a world of cloud-based storage. So that argument used to make a lot of sense. That was a really strong argument for defendants to make. That doesn't really exist anymore. So, you know, if you're facing this sort of issue and you're like, you're facing a big box store or a property owner that's going to make some argument like that, God, maybe at your hearing you bring in an expert or somebody to come say, hey, there was no reason they couldn't have kept this. Okay, that was a side note on duty to preserve. But that's the status of the law. Okay, so in comes Brookshire Brothers. The case in Brookshire Brothers, basically what happens is a gentleman falls in a grocery store. And they save part of the video where he falls. But what's the other element of a premises case? You have to prove that the defendant knew of the defective condition and didn't do anything about it. So what is it that all plaintiffs' lawyers want to prove is that the water on the ground had been there for hours. Well, they didn't preserve the time before the plaintiff fell. So we have no idea how long. I think he slipped in like potato salad or something. I mean,
Chicken fat.
something gross.
Grease.
Yeah. So something gross on the floor at the grocery store. So we have no idea how long he was there. Again, the trial court ruled in favor of the plaintiff, gives the inferential instruction that says, hey, dear jury, because this evidence doesn't exist, you should infer that it's everything the plaintiff says is true. Okay, I'm simplifying it, obviously, but that's what that instruction basically says. And the Supreme Court holds, and consistent with it as it had, that those instructions are like death penalty sanctions, because you're basically telling the jury there's no way around this. I mean, they didn't. And the other thing you're doing is you're letting the jury know that the defendant destroyed the evidence, which also is prejudicial against the defendant, right? And I was real concerned about this in our case because you don't want to comment on the weight of the evidence. And there's judges have this, at least I only speak for one. In a trial, the one thing I want it to be about is always, I want it to be about the occurrence in question, injury in question. I want it to be about the thing that happened. I don't want to try other ancillary issues that may or may not be digestible to jurors, but that regardless of whether or not they're digestible or not, they're inflammatory. So I don't want this case to be about whether or not a 30-day preservation is good or bad. Okay, I want this to be about whether or not this little girl fell, whether or not it was Michael's fault, and what her injuries were, if any. Okay, that's what I want this to be about. So telling the jury, hey, the defendant got rid of all the video is kind of bringing up an ancillary issue. You're now trying the case about whether or not it's okay to have a 30-day, 60-day, 90-day video preservation policy. And it's not just video. I mean, this stuff comes up in premises cases a lot because of the videos. But it can come up anywhere. It can come up in a commercial case. There's email retention policies out there. Where it's also come up since Brookshire Brothers is there's a case, and I've got it written down in my stack of unorganized paper, where there was witness intimidation, where the defendant actually went and exercised influence over a lot of its employees to not testify, and the plaintiff had some evidence of this, and they were like, that is spoliation, and the Court of Appeals agreed. So this can get much bigger. I bet all of you are sitting there thinking about a file you have on your desk right now where someone is saying, we just don't have that anymore. We never kept that. And whatever that is, if I had $1 for every time I've had somebody ask for something off somebody's cell phone, and the response from the defendant is, I got a new phone because I dropped my old one in the toilet, right? Or some puddle of water and it's fried. So I now have a new phone. Like that stuff comes up all the time. So I think this just has much bigger tentacles. Okay. Tell me what else you guys want to know about Brookshire Brothers. Oh, let me tell you what I want to know. So when you go in front of your judge, am I just rambling now? Yes. Stop me if you have questions.
The rambling works for me. I can follow rambling.
Okay. Well, I just feel like there's so much of this that Russ is the guy that keeps me on track. Okay, this is just how my brain works. So you guys you're getting a disservice today because he is not here. right? So you're the, and then you could be the defendant too. The plaintiff could have destroyed evidence, but somebody's gonna set a hearing. And you're gonna call up my clerk and you're gonna say, hey, Lisa, I need a hearing on a motion for sanctions. Which she's gonna think is like they didn't respond to discovery, and so I mean a 2-minute thing on my Friday at 11 docket. You're gonna say, no, this is I need an off docket time because this is an evidentiary hearing. And then you're gonna come down to my courtroom and you're gonna actually put on your evidence. Okay, now you can do it through affidavit, which is perfectly fine, affidavit, deposition testimony, any evidence that you can get admitted. But you can also have live testimony, which is why I say experts, you might want to engage them for this purpose. It depends on how big your case is, whether that financial commitment is justified. But it could be that their evidence preservation policies are bogus. It could be that they the stuff actually was retrievable, right? So like in this case, in the Michaels case, so they say we destroy everything on day 30, they get the preservation day letter on day 33. And I'm not faulting the plaintiff for not doing this, but they could have come in and said, here's an expert that says even on day 33, they could have retrieved all that stuff. They didn't go look.
The corporate rep said.
You had that going for you.
It was not necessarily deleted 100%, but.
They did say that, that's right.
And that's what we hung our hats on. I did consult an expert on surveillance. He said that's absolutely true. It doesn't just delete the tape or the whatever's preserved.
It doesn't just evaporate.
100%. Yeah, it just kind of re-records over what's there. Yes. And I can't remember why we decided not to.
Well, you had not only that, but you had the corporate rep saying.
They were on notice.
Well, she said, this testimony was what I really focused on, was she said, this injury was so big that we were on notice at that minute.
We anticipated litigation.
Because this child was screaming so wildly and out of control, and the mom, I mean, and you can imagine the scene, right? This baby's significantly injured, mom is there. So the corporate rep admitted it. You're not always going to get that testimony. But like the reason I'm telling the story is I think it's just these are ways to get creative and think about, how do I give the trial judge what they need? Because what's now my job after I've conducted this hearing in whatever form it may be? I have to make findings of fact. Okay, this has to be an intense order. This is not an order that just says granted or denied. If it is, it's reversible on arrival. Okay, so unless it's denied. I mean, denied is there's nothing you want to do. But if I'm going to grant sanctions based on spoliation, I have to make fact findings. And those fact findings have to be that there was a duty, that there was breach, and that basically the punishment fits the crime, right? That this will resolve the prejudice. Because in most spoliation issues, but why that last one's so interesting is because money is always the easy sanction, right? And in some cases, I guess money solves the problem. But not in this case, usually, right? If documents or video are gone, no matter how much money I give you, unless it's your complete damage model, does it fix the problem of missing evidence, right? Because the evidence is needed to put on a fair trial.
I have a question.
Yeah.
Is the real takeaway from Brookshire Brothers that spoliation still exists, but if you're really aiming for a death penalty sanction, you really got to have the evidence that justifies almost intentional spoliation?
Yes.
Okay.
Yes.
Yes. And here's another thing. Okay, so let's talk about intentional spoliation, right? Because that's it. That's part of the breach element. Is that the defendant? I'm just going to say the defendant. I don't, like I said, the plaintiff can also spoliate, but the defendant intentionally got rid of the stuff, okay, or lost the stuff, or whatever. It is intentional, and that's another thing Brookshire Brothers did. That's how they kind of took it to this next level. Is it can't just be negligent spoliation, but it can be reckless disregard. Is that the right term?
Yes. I think that's exactly right.
Like I said,
Well, there's negligent spoliation in there.
There is negligent spoliation, but negligent spoliation is not enough to get, you might be able to get a minor sanction on negligent spoliation. But if you want anything with any team that's really gonna be worth your time and doing all of this, it's gotta be intentional.
Well, and don't
But
ask
you
for
talk
death
like-
penalty unless you've got video of them destroying the video.
Yeah, and I gotta say on the record, well, and you know what, here's another thing that I would say, on that is, you're just putting a red flag on your mandamus. If you get the jury instruction, right, like, here's another thing, okay, I'm going way off topic here. My advice to trial lawyers, what do you want and what do you need? And they are oftentimes different things. Recognize the difference. And if you're trying a case, and this is true no matter what it is, you think you're gonna win, give the other side what you can, because you take away their appeal, right? Best way to win an appeal is to win your trial, but take away their appeal. If you're writing a jury charge and the other side wants some crazy wackadoo question, okay, or you're getting into one of these arguments about whether or not to use the word injury in question or occurrence in question, and you think you're gonna win, like you've got them, you're feeling the jury and they're feeling you, give them what they want. Because then you've cut them off at the knees, right? So in this instance, like, did the plaintiff in this case need an instruction in the jury charge that says you need to infer all this stuff against Michaels? Did they need it? They wanted it, but I don't even think he wanted it.
No, I mean, we wanted to be able to talk about all the stuff they destroyed. If we got that instruction, I don't think we're gonna allow us to really, to go very far into the destruction of evidence facts, which was our B story in the case. Look, you would have loved to have had it in a perfect world where there was no, if there would have been no appeal. Right. But what could you live with? Okay, so I get a little goodies. I get a few things that help me. Now I can use that to get, I mean, we had a kid with a traumatic brain injury. You're gonna do well here.
Is it an appropriate sanction to just let the aggrieved party talk about where all the stuff disappeared to without the
So
instruction?
Brookshire
Is that
Brothers says
permissible?
you shouldn't do that unless your court makes factual findings that talk about why that's the right sanction to give, which I did in this case. So you can get there. Again, I would say go back to Brookshire Brothers. Find that's like, you know, in a recipe for a cake, there's like a cake, and then they tell you how to make the middle cream part, and then they tell you how to make the icing. This is like the icing. That formula is there. If you want, if you're like, you know what, the best thing here is to talk about the fact that they got rid of the video. In our case too, it was also this cart. They never saved the cart. And the plaintiff's argument was that the wheels got like gummed up with like hair and ribbons and just dirt that would happen in a Michaels. And they got rid of the cart. I mean, it was gone. So no one could look at it because the plaintiff's story was that the wheel buckled, and that caused, when mom goes to push, it causes the cart to go like this. The defendant's argument was, nope, none of that's true. The kid was in the little girl was in where the kid sits and is reaching for some of the chocolate bars and stuff, and that wiggling caused the cart to go down. Well, you know what would be really helpful to look at? The cart. It's gone.
This might sound like a really simple question. Do you have to send a spoliation letter to make your spoliation argument?
No, it's just good evidence, right? In your hearing, if you can say, look, lawyer appeared on day 30. Yeah, it's just good evidence. Now, and the other side of that is true. I mean, what if the lawyer sends a letter that's like, I mean, we're just really curious, and it's not like we're going to sue you or anything, but we're just wondering what happened. And I mean, you would never send a demand letter like that, right? But what if you did?
Dear Walmart, Are there chances you have video just?
It's
of
not like
stuff?
we're gonna sue you. I mean, we're really not even thinking about doing that anyway. I mean, we just wanna know.
We just collect these things. They're really cool. They're making blooper.
Right, if you wrote that letter, then I think Walmart could come in and say, this letter doesn't put me on notice. Even if it was there on day 10, right? Yeah,
Where's some examples of some other type of sanctions, minor sanctions?
okay, so let me tell you what we did in this case. And if I forget something here, it's gonna fill in. The first thing I did is I said that they need to talk about the fact that the cart was missing, because the experts were gonna all have to come in and talk about, they used what the term was like exemplar carts to determine if this accident could or could not have actually happened the way anybody says that it did. And the defendant's argument was, Judge, the sanction is just strike at us from using our experts. Okay, but how does that help the plaintiff? Because if no experts come in and testify, they don't get to prove their case. So I'm not going to just say the experts are unreliable or they're just speculating. So I said that they could talk about that. The other thing I did is that okay, so in this case again, the plaintiff, okay, so no, I'm sorry, the defendant filed a motion to designate mom as a responsible third party. Okay, that she wasn't keeping an eye on her kid, kids now reaching for the candy, that's what causes this to happen. And right, an RTP motion is pretty mechanical. If the defendant pleads enough stuff, I don't have a lot of discretion in there, right? If it meets the elements of the rule, hold on real quick, then I designate, then I'd say, okay, so designated. Now, they can move for some judgments, that doesn't mean it's been submitted, but so designated. The loss of this video really defeated mom's ability to refute that. So I struck the RTP. I said, that's not coming in. What else did I do? Struck the RTP, said you could talk about what happened with the spoliation.
I think there were some limitations on their experts' testimony also, wasn't there?
I should have prepared that.
Maybe, I mean, I can't remember what's argued and what,
Yeah,
what
and
actually ended up in the order, but,
and I don't want to sound like I'm too defensive or arguing the plaintiff's case here, because my objective in all of this, right? I heard somebody say this when I first got elected, which, by the way, if you haven't all voted, please don't do so. Today is the last day of early voting. But I heard a really smart person say, you know, I used to represent plaintiffs. Some of us used to represent defendants. We no longer do that anymore. We represent the law. My only goal is to have a fair trial for everyone. And I know I'm talking to a room full of a lot of plaintiffs' lawyers, I'm guessing. Maybe not. That means for the defendant too. A fair trial. Not a unfairly weighted trial. So I don't mean to sound like I'm arguing for the plaintiff. I thought what I did was the right thing, because the plaintiff was in this predicament through no fault of their own, having to prove a negative when evidence would have existed that would have cleared all this up. Through no fault of the plaintiff. Yes.
Is there I mean, obviously you don't want to dive into this before you have the evidence or taking the court with that depot, but sometimes you can because it's obvious. Is there a preference for the courts when these issues need to be brought to the attention? Like, you want to wait till pre-trial? You want to do it early on? Or does it maybe just depend?
Well, again, I can't speak for the plaintiffs in this case. My thinking is that they thought no way was I ever going to grant this. So they did it at the pretrial conference, which I wish wouldn't have happened. I wish it would have been a couple of weeks before that, at least, if not months before that, because what it did in our case, we had set aside 2 weeks for this trial. They run down to get the mandamus, they get a motion, they get the stay granted, and all of a sudden I have 2 empty weeks with nothing to do. If I would have known, if I'd had a little more advance notice, I could have plugged in another case to try that week. right? But I couldn't get to somebody fast. I mean, look, I had plenty of work. It's not like I just, went on vacation. I did have a vacation around this time period, but that wasn't work. That was something totally different. I wish they would have done. I wish she'd have done it earlier.
I know, I'll just say, and I agree, and I wish the mandamus wouldn't happen and you're the way either, but things got better during that year for our case.
But mandamus is gonna happen.
Yeah, but the issue was, we were, and I can't believe they agreed to it, that Michael's agreed to it, but we got a really tight trial date. So we only had about 9 months to work that case up. And we started working on the spoliation issue day one. Once we found out there was no cart, no video, no incident report, we got together and said, okay, guys, we're going to do something on spoliation, but we're going to make sure we don't get too greedy. We're not going to ask for instruction. We're going to use it. I don't know. Maybe we'll attack our experts that way because we know they're going to say, this is how the accident happened, definitely, and there's no card to examine, so we're gonna have to use the spoliation to respond to that. So we didn't have all the depositions we needed. I mean, we were working just as hard in developing the spoliation case as we were on developing the liability case and damages. And so it really wasn't until around pre-trial time that I said, okay, guys, let's go. We've got enough material. Let's file a motion. She's gonna freak, and it's gonna get denied.
I'm not faulting you.
We didn't have a lot of time, and that was me.
And I wasn't in the room when they, of course I took this under advisement. I wrote my own order, I faxed it out or emailed it out. We don't fax anymore. I know that. I'm showing my age. I wasn't in your office when you got it. And then, somebody runs in your office and is like, oh my God, did you see this? I mean, I assume that something like that happened. And likewise in the defendant's office where somebody runs into somebody else's office and is like, are you freaking kidding me? I'm sure that's what, he had a question first, but did I answer your question?
Well, I'm the host, so I kind of get to decide.
I'm picking it.
I think I answered my own question.
Okay, so to follow up though, yes, I would do it. The more in advance you do it, the things you do, give your judge time. Okay, that's the first thing, because you have to have a fact-finding order. I think my order was 7 pages. So you give your judge the time. If it's a significant case and a significant sanction that you are asking for, right, and you need to factor this into it. The thing that they gave up was the trial date. I had a trial set in June of 2020. That meant we couldn't have gotten to the case until 2021, 2022 because of the appellate stuff that was going on. I mean, it could still be sitting in the Supreme Court for all I know. So in exchange for this, you're giving up time. Are you willing to do that? I mean, maybe the cost isn't worth the ride or the ride isn't worth the cost. Also, so you have to anticipate mandamus. Which gets to an interesting point, which I really struggled with in my own intellectual world is the proper remedy mandamus or is it just an appeal on the merits, right? Death penalty sanctions, the Court of Appeals say that's mandamusable. Because if, that they just say that. The standard on mandamus is, does it impact a significant, substantial, or procedural right? So death penalty sanctions, mandamus, easy. Is it that, or is it just a regular sanction order? Is it just a discovery order? Because if that's the case, then you appeal after the entry of a final judgment. I mean, the one thing that we don't have from the Court of Appeals, they just issued the petition for mandamus is denied. I don't know why. They could have thought that it was the most brilliantly worded order they'd ever read, and so petition denied. They also could have said, this isn't a mandamus issue. This is something to be appealed on the final order. And I guarantee you, if we'd have tried this case, this issue would have made its way back into the appeal. Yeah.
I didn't realize that we had to trying to handle the case here, but did you guys think about doing it before so that mediation or kind of like, hey guys, you got a pretty good spoliation thing here. I think you would need to evaluate the thing differently.
Yeah, it was a narrative that was part of the case from the beginning. I mean, they were aware of what we were doing. We took depositions that were, if they weren't solely for spoliation, they were heavily weighted on that issue. And so
mediated?
twice.
Was it used by you all kind of trying?
Oh, definitely. Yeah. I mean, it was a major issue. And like I said, we agreed on really tight deadlines.
Yep.
On the argument that this little girl needs medical treatment, needs some resolution, sooner rather than later. Michael's was really agreeable to that stuff. But the risk we ran was, asking for what we asked for, and having to do it in our mandamus. We had our fingers crossed, hoping that mandamus denial would be, this isn't mandamusable. It's denied. That would come in, 2 days or something. And it took 6 months. But
The judges on the panel were Wise, Jewel, and
Spain,
so, right, I mean, I know all these people, I think they're smart, they're all smart people. But I've got 2 conservative Republicans, one who I know used to represent Walmart, and I'm thinking, no way. I mean, may have actually written the amicus or written the brief in the reindeer case, for all I know, and I'm thinking, there's no way, so it could be that just saying, I mean, I can't get in their minds, I'm not a fly on the wall. It could be that they just didn't want to wade into, they didn't want to give my order any more oxygen, right? Like if they wrote an opinion on it, they're validating what I've done. If they deny it, the petition for mandamus, there's, who knows why we denied it. I've also heard, and I found this to be true, that at least as far as Justice Wise is concerned, that he's pretty wants to limit the scope of mandamus. So it could be that. I don't know the answer. And all of this is right. Like we as lawyers, I did this, I'm sure you all do it. You're like, oh, Judge so-and-so, they do this. And you start having this urban legend about what certain judges do. And some of that may be true and some of it may be total yes. I don't know what you guys say. I mean, I kind of do.
Mostly nice things.
I'm sure. Okay, so that's what you need from your trial court. We talked about whether or not this is an appeal or a mandamusable issue. We can talk about what time is it? Am I right? Am I rambling?
You are at 12:54.
So some of the cases since then, I mean, one of the things is, right, if I was a transactional lawyer and I had to advise my client on having a video retention policy, email retention policy, a bank record retention policy, what would I tell my client? There have been courts that have held that a 3-month retention policy is not unreasonable. I speak a lot, as you can tell, I talk a lot. I probably say more in a hearing than I should. One of the issues I was concerned with is this idea that allowing corporations to have these retention policies that are just arbitrary, really it's like shrinking your statute of limitations. You can file your case for up to 2 years. There's just not going to be any evidence to support it, right? Like you basically cut me off at the kneecaps because you said 30-day retention policy, and there's no rhyme or reason behind that. I have a fundamental problem with that, but at the same time, I know that you have to advise people how to run their businesses and how to conduct themselves. One of the things that Russ always brings up is, remember, there's no duty for these stores to keep these videos in the first place, right? They could just say, no more video inside of Michael's. Or a Brookshire Brothers grocery store, or a Kroger, or a Walmart. They could just say, we're done with video.
And then they get robbed blind by their cashiers and they're more worried about what they're going to lose from that.
So that they have to make that decision.
Right.
They have to make that cost benefit analysis. And they're trying to limit exposure. I get it. I don't live in a fantasy world. I understand what's going on. But I would be advising clients, if I represented them, if you're going to have one of these policies, have a real good reason to have it. Especially in light of technological advancements in data retention. let's see, so other cases, other instances in which this has been used, this was a family law case. And I mentioned this goes beyond just these examples we're talking about. Mom sues dad in a custody case and basically has accused dad of having child pornography on his telephone. He doesn't have the phone anymore. What a surprise. But the Court of Appeals holds that because an accusation like having child pornography is so inflammatory that it's almost this heightened standard that it gets at. Like, we're not going to just let this come in unless we are like really sure. I'm paraphrasing, okay, to just have this how we normally talk as people. But I think what's interesting about that is, in a case with a traumatic brain injury in a baby, is it going to be treated differently than dash cam video on a rear end car accident? Yes. Should it be? No, right? In a perfect world, it should all be treated the same. Will it be? Probably. But you're not going to put the time, effort, and money into probably a spoliation in a rear end or dash cam video situation. I mean, you might, I don't know. I have that case on your desk right now. No idea. Okay, let me make sure I covered everything. Anything else? Do you guys have any questions while I'm looking at these notes? So 3 months is okay. Case is Bragg versus Walgreens. Case about the child porn is.
Write this one down.
Oh, I don't have, wait, do I have that? No, I don't have that. Oh, here's another thing. Another thing that I see lawyers do all the time when I'm ancillary is what I call the evidence preservation, TRO. Judge, Watson grinding just exploded, and I need you to order them to preserve all the evidence. Okay, they're under a duty to preserve all of the evidence. Trust me, when a big explosion happens, companies know there's a substantial chance of likelihood of litigation.
Excuse me. But you don't really get a good press fight on television unless you get on
Well,
TV and say, I went to the court immediately.
I know what's going on, but then, the plaintiff comes in and they say, well, Judge, I'm not really asking for anything that they should be disagreeing with. That's legit. I mean, and so evidence preservation TROs are granted all the time. And I've always thought, are we doing it because no harm, no foul? Are we doing it because right, a TRO, you shouldn't get it if there's another adequate remedy by law, which, hello, spoliation. If there's a big explosion and then they do magically get rid of all the documents, isn't that spoliation? And the Court of Appeals has said, actually, no, spoliation is not an adequate remedy by another adequate remedy. So you can get the evidence preservation TRO because you have to prove this intentional element. And they may accidentally get rid of all the stuff, and then the stuff's just, so that's another fun fact.
Judge, thank you so much for your time.
You're welcome.
So glad to have you. We're doing this in another month. If you're nearby Greenway, come on down. We're about to serve lunch, but if you got any questions, you want to email, I can forward them to the judge. Also, all these cases are going to be in the paper, which we're sending out to everybody. So thank you, everybody.
And again, if you meet Russ Hollenbeck ever, or you see him, just ask him to go off on this, and he's going to tell you so many of the right answers legally. I can tell you practical stuff. He's the legal guy for sure. So.
All right. Thanks, everybody, for showing up.
Yep. Good luck.